themselves, especially as we move into a political season. One of the things that MediaPost has done assiduously over the last decade is follow the policy, and Wendy Davis has always been the lead for this. She has been a specialist in policy for MediaPost for a number of years. Let me turn it over to Wendy Davis.
Steve. Thank you. So I'm here with Cathy Dwyer. She is a professor of information technology at Pace. Alison Pepper, Senior Vice President of Government Relations for the 4As, and Elliott Siebers, an attorney with Frankfurt, Kurnit, and a former Attorney General in New Jersey who worked on privacy compliance issues. So let me start by looking at kind of what is going on in terms of the laws. California has a new privacy law. It went into effect January 1st. It's not supposed to be enforced until July 1st, and there are regulations that have not been finalized yet, but it is theoretically enforced now. Maine is getting a new privacy law that takes effect in July. There have been new bills proposed in New Hampshire, Illinois, Virginia, Florida, Nebraska. Some of these have been modeled on California. Some of them draw from both California's law and the GDPR. There was a proposal in New York that I don't think drew from anything for a 5% tax on all gross revenue of corporations that collect data. There are a bunch of federal proposals. There have been 2 Democratic bills floated, but there have also been bills to regulate algorithmic fairness, to regulate so-called dark patterns, which are just ways of getting people to consent to share their data. So with all of this activity, one question that I think comes up is, why is this happening now? You know, the cookie has been around for 25 years. The iPhone has been around for 13 years. Why now, this year, are we seeing all of this new activity? Let me throw that out there to everyone.
I'm next to you, so I can
Go ahead.
I can start. I actually don't think 13 years is a very long time. 13 years ago, that's when the iPhone and the Android came out. So if you think about cars, and 13 years after Henry Ford made his Model T, there's a lot of regulation that's different about cars compared to, let's say, whenever that was, maybe I'll just guess, 25. And the other thing is that regulation usually addresses the secondary impact of technology changes, the way it affects the way we relate to each other, the social impact, and that sort of bubbles up. It's not really apparent at first. It's something that we go through our day, and then all of a sudden we realize that we're addicted to our phone and we can't have it be more than 5 feet away from us, and we don't quite remember how that happened. So, so these are all issues. They affect children. They affect our relationships with our most loved family members. So I think we all want to think about it and make it better.
So, I would say the focusing event for the absolute explosion of not just regulation around privacy, commentary around privacy, et cetera, the catalyst event probably is Cambridge Analytica. And it's not like that's the first instance in the past 15, 20, 25 years where we've seen data being used in ways that are a little bit on the nefarious side. But I do think Cambridge Analytica really was that catalyst event that started what we've seen, everything that comes after. And the reason I say that I think that was a little bit of a catalyst event is I do think Cambridge Analytica was a little bit of a watershed, where before I think we were talking a little bit, at least in some of the DC circles and state circles around privacy, like, oh, it's creepy that this ad for, Louboutin shoes are following me around the internet. How is that happening? Why is that happening? Cambridge Analytica was a little bit, I think, where this issue really worked into the public consciousness around, hey, this isn't just about shoes following me around the internet. This is about the ways that data can be leveraged to affect our social fabric, the ways data can be leveraged to affect things about employment, about education, about housing, about healthcare, about homeowners insurance. Data is being used in ways that are particularly could be detrimental to me in ways that I didn't even know about. And I think Cambridge Analytica opened the door to a lot of people's eyes, both the public and regulators on that issue.
Do you think the fact that Cambridge Analytica was a political consulting firm and that they may have played a role in actually affecting the presidential election results is another factor beyond kind of the abstract idea that data can be used to influence social issues? I mean, do you think that the nature of the presidential election itself played a role?
It could be. I mean, listen, the acrimonious nature of the 2016 election was due to a lot of evolving societal issues that were outside of data, right? So it wasn't just data, but I do think the increasingly acrimonious societal nature of our elections and our divided America played a part of it, but it wasn't the whole reason.
What do you think, Elliott? Why now do you think we're seeing all of these laws?
I think that part of it comes down to one man, Alistair McTaggart, and his ballot initiative that ultimately became the CCPA. I think that I agree with Alison very strongly. In addition to the passage of the CCPA, the sort of work that regulators have been doing in the privacy space, just using state consumer protection laws, combined with, I think, strong feedback from their constituents that issues like Cambridge Analytica, the Equifax data breach, are of concern to them and matter to them, and that they want more tools in terms of how to control their online data. That is heard in state houses across the country, and there's this rush to try to react, I think galvanized by the CCPA.
And you had mentioned Alistair McTaggart. Does everyone know Alistair McTaggart and what role he played in the CCPA? Is that familiar? He was a hedge fund millionaire, billionaire, I think the story is that he was at a cocktail party and talking to someone, and privacy came up, and he became very interested in what was happening with online data. And he sponsored a ballot initiative in California, and the ballot initiative would have given people in California many of the same rights that the CCPA actually ended up giving them. And he got enough signatures to get this issue on the ballot for the election, the 2018 election, and in California. And it was polling extremely high. It was polling at something like 70 or 80% support. And the tech industry and the ad industry was very concerned that if this initiative actually was voted on and passed, that it would be the law, that it wouldn't be possible to go back and amend it or to go back and revise it the same way that they could with legislation. And at the last minute, he agreed to withdraw the ballot initiative if the California legislature passed the CCPA. And so in a week, they did. They pushed it through the California State House, and it was signed within a week of being introduced in June, and at the last minute, he withdrew the ballot initiative. He is now talking about a second ballot initiative. There's been a lot of uncertainty about the CCPA, and there are a lot of conflicting interpretations of how it applies to tech companies and how it applies to advertisers. And he and some other privacy advocates they're working with the AG to try to clarify that in regulations, but he has also said that he's now pushing a new ballot initiative that would, by ballot initiative, clarify those same issues and make it clear that that if people opt out under the CCPA, their data can't be used for ad targeting. But so let me ask you, Elliott, the CCPA, what does that actually require companies to do?
Well, depending on the company and what it's doing, if you're interfacing with consumers, you're likely collecting their information and likely using that to monetize your website in some kind of advertisement. So the collection of information is really what the CCPA concerns itself with. And there's a series of rights that the CCPA creates for consumers in California. Those rights involve the right to access the information that a company has collected about that consumer. So that's the specific pieces of personal information as well as general categories of the information that's being collected, what information categorically, the company is sharing with others. There's the right of consumers to have that information deleted, and they can submit a deletion request to a company. And if a company decides that it sells personal information to third parties under the CCPA, it's also required to provide consumers with a means to opt out of that sale of information through a button or link at the bottom of its website, and that would prevent a consumer, at least as to that browser or on that device, stop the collection of their information to be used in the sale of information for advertising purposes, as to that website. It's, I think, a little bit difficult for a consumer to navigate because there would then have to be instances across every website that a consumer is interacting with to opt out. So I would say there's consumer rights, but they're sort of limited and not general to every instance of where that consumer might be targeted for advertising online.
So my understanding of this bill was that the backers intended for this to give consumers the right to opt out of targeted advertising. Is that how companies are interpreting this bill?
I'm sorry, could you repeat that?
I thought the backers of this bill intended that it would give consumers the right to opt out of targeted advertising. Is that how companies are is that how the advertising industry and companies are interpreting it?
I mean, I would say that because of the broad definition of sale under the CCPA, it's not simply an exchange of a consumer's personal information for money, but for valuable consideration. It's not an exchange in the sense of handing over a discrete data set, but even just making available. It's very broad and sort of flies in the face of a more traditional definition of sale. And some companies are taking more of a wait and see approach once enforcement starts to happen and once maybe the regulations are finalized, and may provide some more guidance and clarity around what the extent of sale is and what the expectation of the AG is for companies and how to effectuate a consumer opt-out. I think that there's some companies just standing on the sideline and in the meantime still delivering targeted advertising, but under the guise of a business purpose or under the guise of sharing that information with a service provider, another technical definition within the CCPA that permits sharing of information with a service provider so long as that person is under a contractual agreement to not further use that information other than for the purposes for which it's being shared.
Yeah, can I just add to that? I don't think it's purely accurate to say the goal of the bill was to allow consumers to opt out of targeted advertising. So McTaggart...
One of the goals.
One of the goals, but I don't think that was the initial goal. I mean, you mentioned I guess it's urban legend at this time, but McTaggart is a very wealthy real estate developer in the San Francisco Bay Area, and Wendy's absolutely correct. The story is that he was at a cocktail party, and it's either a Google, Instacart, or Facebook engineer, depending on who you talk to, who apparently said, hey, you have no idea about all this information that's that's going on online. You have no idea all this data that's being collected. You have no idea how all this data is being used. And supposedly McTaggart's response to that was, oh, tell me more. And tell me more is what led to the CCPA ballot initiative. But when you talk to McTaggart, he has said publicly and in print repeatedly, my goal was not so much, I'm not looking to decimate the online advertising industry. He said, I'm looking to force the industry into more transparency than I think currently exists. And I think another example of why McTaggart's goal was not to decimate the online advertising industry is because he has specifically said he decided that his ballot initiative should not purely track GDPR, which is a consent model, and instead it should be opt-out because that was more in his lines about transparency. So if he had been purely just been about, well, you know, this is about following the GDPR model and we're going to go to the Europe model and my goal is to decimate online advertising, it probably would have been a consent model and not an opt-out model.
Go ahead,
I just
Cathy.
wanted to also say, the things that you mentioned, Elliott, from the California bill, they sound like they're right from the Fair Information Practices, which goes back to at least the 1970s, I believe. And if you sat down with, you know, any person who's not a lawyer and who was not in advertising and said, well, here's the 3 things that we think companies should do, I don't think they would think any of those things were like really egregious, and they probably would think that they're actually a very good idea, that they would have this agency to kind of investigate. One thing that comes up, it's not really in advertising so much, but in terms of these data brokers, what happens when invalid information gets put into your record and your financial status gets affected by that? Do you have any ability to go in and correct stuff? It's usually quite difficult. So one of the things that came up in the previous panel was how brands are a little bit afraid about, you know, showing their ads next to bad stories. But do you really want to be on the side of, well, it wasn't a sale, so we don't really have to give you all these reasonable things?
Well, I was going to ask that also. I mean, does a company run a risk, even in terms of public opinion, by saying, we don't think that targeted advertising is a sale of your data, therefore, even if you opt out of the sale of your data, we're still going to target you with ads. Does that pose a risk, either, if not legally, then to a company's reputation, do you think?
Yeah, it absolutely does. I mean, to be fair, though, opting out of targeted advertising, that's been an option that's been available since 2009.
Well, that's right. That's right, through the industry opt-out page. The bill says the companies have to put a do not sell my information button right on their websites. And then there are questions that are still being sorted out about what to do next. But the preliminary regulations said that one way companies can honor that is by honoring the do not track headers. And that's a setting that consumers would just do once in their browser and wouldn't have to go and opt out individually or opt out through an industry-run opt-out page. And I think, for whatever reason, you know, there's been some pushback against that by the industry.
I think of more interest to me would be just to see how I've been profiled, not necessarily how I've been targeted, what bucket have I been put into. I would definitely like to see more of that.
Yeah, I'd actually follow up on your point too about, you mentioned about, well, one of the concerns in this space would be financial information, right? Yeah. Like let's say I'm reported delinquent on my mortgage, right? I get reported delinquent on my mortgage. Those type of harms, I think, are absolutely the type of harms we should be talking about in this space. And they're concepts that aren't new. I mean, you look at the Fair Credit Reporting Act, right? The Fair Credit Reporting Act was passed in the 70s? 70s, yeah. The FCRA was passed in the 70s. And at that time, Congress said, listen, there are legitimate harms that can happen to consumers if financial information gets basically reported incorrectly to the bureaus. You know, we know the big ones, Experian, TransUnion, Equifax, but there's quite a few smaller ones as well. And Congress said these are legitimate concerns and these are legitimate problems. What's in your credit report can very much impact your housing. It can impact your employment. It can impact your insurance. It can impact all kinds of incredibly important life decisions. So the FCRA, although imperfect, no doubt about it, although imperfect, the FCRA was the time where Congress said, let's start by focusing on what kind of harms are we concerned about and how do we help people address them. Now, I understand the FCRA is imperfect and it can be very difficult to dispute things that are on your credit report. But to balance that out, if it were very easy to change your credit report, it wouldn't be a valuable tool.
One of the things that the CCPA requires is that companies, you know, tell people that if consumers request to see their information, companies make that available. Often in the past, companies have relied on this broad idea that of a privacy policy. And they say they'll let consumers know what's happening to their data by telling them in a privacy policy. And there's a lawmaker in California, Hannah Beth Jackson. She was just interviewed about this yesterday. She says privacy policies are probably the next battleground in California. And what she said was, I'm an attorney. I practiced law for 22 years. Most of them are absolutely incomprehensible to me. Or they take 25 minutes, and I think they're designed, frankly, to frustrate the user. So, let me ask about that. If there is some if this is going to be the latest front in privacy, what does the research say about privacy policies?
There's been some, academic research where they figured out how many person hours it would take if you actually read every privacy policy of every site that you went to and how it would affect GDP and the overall performance of your company because you'd be spending so much time reading these things. Of course, none of that's going to happen. But the policies can only, I think they're being asked to carry out too many roles. They certainly have to define areas of risk for the company itself, but can they simultaneously serve as a data transfer, data flow transparency mechanism? I don't think so. And these mechanisms are quite interesting. We were talking before we came up here about the use of ghostery. And so I teach information technology. I actually teach a course in social and mobile technologies. And I assign them to use ghostery and see what they think about it and see what they can find out about it. And I really would like more tools like that to be around. And I think that makes advertising a little bit more safe or a little bit more reassuring that they're not, that they're not trying to hide what they're doing, that they feel that there's a way that you can expose this and explain it. And I think that's just better for the industry as a whole.
Right. I think that it's a little bit ironic to hear a California lawmaker complain about how complex privacy policies have become. That's in large part driven by the specialization within the legal industry, where people now have to focus and dedicate themselves to privacy laws like the CCPA, and all of that experience gets baked in to drafting them, and it becomes much more of a document that's regulator-facing as opposed to consumer-facing. I think that some companies are taking steps to invest in more consumer-friendly ways to communicate their privacy practices. There's layered approaches where you're giving just-in-time notice when you're collecting information and letting the consumer make a choice at that time as to whether or not they consent. I'm an Android user. I know many of my apps now offer the selection, allow an app geolocation data access all the time, allow it only when I'm using the app, or deny it altogether. Those types of menus of options, I think, are evolving. There's more consumer choice at those moments as opposed to in a privacy policy in a very lengthy and sometimes, legally dense document. Ghostery is a great tool as well, I think, for consumers to help get insight into what's going on in a web page that they visit. But I think beyond that, larger tech companies like Google now offer privacy checkup. You can go through and look on all of your Google services, what it is that they're collecting and what the settings are that relate to your privacy. I think that's a pretty far out there example, and Google obviously has good reason to invest a lot into making sure that they're being transparent and giving consumers opportunity to exercise control over the data that Google is collecting and using about them. But in terms of individual publishers, I still think that there's opportunity to think beyond just a 13-page privacy policy that's linked at the bottom of the page, and find ways to condense that or layer notice so that it's just in time on your page and consumers are giving more discrete notice that's, I think, really a trend in terms of a best practice that's developing within consumer disclosure space.
That's interesting. Well, I mean, Alison, I think the ad industry wants to kind of move away from privacy policies altogether, right?
Yeah, let me nuance that one a little bit. I think talking about California and privacy policies is absolutely the right place to start, because the practicing attorney can correct me if I'm wrong, but I think California with CalAPA in 2002, 2003 was the first state ever to essentially mandate privacy policies, right? So California has been, I guess, pioneering the privacy policy front since CalAPA.
That's right.
Yeah. So I'll take a little bit of a contrarian point of view on the privacy policy issue, and I'm not anti-privacy policy. Let me state that in case that gets lost anywhere. But I wonder if we're not barking up the wrong tree on this one. And the reason I say that is, you know, I talk to Hill staffers so much, I talk to state staffers so much, I talk to a lot of consumer advocates. This idea that privacy policy in terms of use are going to be the panacea for all ills, I don't think that's going to be the right approach going forward. Transparency is important, and I agree with what Elliott said. Unfortunately, privacy policies are a little bit like practicing defensive medicine. They're increasingly written by lawyers, for regulators, right? So there's probably a hybrid approach going forward here that I think would serve both the needs of consumers, regulators, the industry. It's not a winner-takes-all approach. But the problem, I think, increasingly with focusing on privacy policies in terms of use, and that if we just did a better job of presenting these to end users, all ills would be cured. I think everything we read from a research, not everything, there's always going to be exceptions, but a lot of research we see increasingly, and what we see with our own eyes, anecdotally walking down the street, kind of tends to lead to the impression that attention spans are getting shorter and shorter and shorter. I was kind of joking with Wendy a little bit when we were planning for this meeting. I said, short of writing a privacy policy in haiku, I'm increasingly wondering who's going to read it, right?
It's an idea.
We should have a contest for writing privacy policies in haiku. But consumers agree, layered approaches are one thing, real-time notice is one thing. That's been, real-time notice on privacy policies in terms of use has been suggested as a way to put, immediate notice in front of consumers. But then a lot of research shows that annoys consumers, right? That annoys consumers and interrupts the viewing experience. So I think we're probably looking at a hybrid approach.
And
Sorry.
by hybrid approach, you're talking about, my understanding is an approach where certain uses of data would be presumptively illegal. So to use data to make a decision about whether or not someone insurance or credit would be presumptively not allowed, but that other types of uses, like for advertising, would be presumptively allowed.
Yeah, one approach to that would be, for instance, you would, I think, and you're going to have baseline privacy legislation on this, but one way to effectuate baseline privacy legislation would be to have legislation, for example, that says, listen, you cannot use any information you got via tracking, you cannot use to make college admissions decisions, you cannot use it in employment decisions, you cannot use it in insurance rate setting decisions. I think you are going to actually need some kind of baseline privacy legislation that addresses those harms.
And the flip side of that it would be presumptively legal to use that information for advertising. And I guess the thought is like, well, this just benefits consumers, it benefits companies. Is there any issue of that being kind of a paternalistic approach, do you think? Go ahead.
I'm not quite sure of your question.
Well, so I think the ad industry is kind of promoting this view that data, that it shouldn't just be opt-in or opt-out, that, that certain uses of data should be illegal, so that using tracking data to make a decision about insurance rates should be illegal, but that using data to decide which ads to serve to people is just something that would benefit the consumers and benefit the companies, so that does not need the same kinds of protections. So I guess is there a thought that a legislation that says, well, this type of use of data is beneficial, so that's fine. Is there a danger of paternalism with that, or?
In terms of the issue of things that are not really clear-cut, it really has to do with what process you go through to get input from stakeholders and and see how people feel about things. You know, there are these outliers, like, as you mentioned, insurance, and it's not hard to get agreement on that, but other things, it's going to take some time to tease out what the issues are, and I guess it is kind of paternalistic to sort of put things in two categories, either really, really terrible or fine.
Right, and this approach, you know, sounds familiar. This is the approach that FICR took, right, in defining what a permissible use for a credit report is and who can access one and how far they can go in terms of using that to make a decision. I think there, though, the basis was there's harm to this information being used in ways outside of, say, extending lines of credit. So it would come down, I think, to a process and getting consensus on, well, what is the harm to having online information being used in algorithmic or other instances of decision making? What does that mean in terms of the impact to a consumer? And what do we want to do to try to mitigate against that? And that might be legislation that says there are impermissible uses for information that is collected online, and you can't, say, put that into an algorithm and not have any insight into how that information translates into an outcome that affects that consumer.
Yeah, I mean, I absolutely agree with that, because I've been in this space for over 15 years now, and it just increasingly feels like we're going about this the wrong way. I think you do have to start with harms, because a lot of the legislation I'm seeing right now, it's starting with the technology and working to harms, right? Mm-hmm. And the truth is, particularly with how incredibly difficult it is to pass anything in Congress right now that is not, you know, NASCAR day or budget. Mm-hmm. Everything in between is having a little bit of trouble passing nowadays. How difficult it is getting anything passed. If we enshrine technology in the legislation, it's going to be outdated in 4 years, maybe less, at the way things are going. And that's why I think if you do not take the approach, what harms are we solving for? Because the harms from a societal point of view should remain relatively constant. It's the technology that's going to change rapidly. So I think you start with harm and then make it technology agnostic, but you have to start at the harm table.
So what is the best way to address a Cambridge Analytica type of harm? I mean, that's really just using online tracking data for political advertising or for advertising. What is the best way to address that?
Well, I think it's a complex problem, and it's going to take some stages. But one of the things that I think got Facebook in trouble is that they felt that they felt people had already agreed to having their information shared, and because they had friends and they used apps, and therefore their friends were on the apps, and their friends could take all the apps data.
And they didn't opt out. It was a buried setting where they could opt out, and they didn't.
Yeah. So if there are these technical assumptions baked into your tool that sort of assumes that because someone agreed to this, they also agreed to that, well, that's eventually going to bubble up, and you're going to find it. So that's what's good about transparency. These things get revealed. And then you can have a debate about them, and then you can talk about other ways to address them. So I'm all for transparency.
Transparency. You all agree?
I mean, I would just say the best way to avoid that, maybe bluntly, is just to deactivate your Facebook account.
No, I mean, if you're in Washington and you want to pass a law that's going to address it. No.
So, you know, I think I agree with Cathy there. I think transparency goes a long way. I think, you know, the issue there is consumer whiplash in the surprise of having had their information shared through a way that they may have consented to, but wasn't entirely clear, or was, you know, permissible under Facebook's terms at the time. What was impermissible was that this guy, Professor Kogan, commercialized it, right? He could have used it for a study under Facebook's terms. So I think that regardless of the of laws like the CCPA and whatever consumer rights they might create, and however companies like Facebook might react and implement them, there's still a larger requirement that's been the baseline in American privacy law, which is transparency and truth and accuracy in disclosing what it is you're collecting from consumers, how it is you're using that, and who you're sharing it with. So I think even as companies are working through implementing the CCPA or whatever comes next, there's the baseline expectation, legally, but also I think from consumers, that there's, if they do decide to read a privacy policy, going to be a piece that, to the extent they can interpret it, if it's written in jargon, it's still going to be accurate. It's still going to be truthful. And that if they put that time in, there's going to be something that they get out of it in terms of understanding how it is they're interacting with the company.
Could just, on the political advertising one, how data is going to be collected and utilized for political advertising is going to be a lot harder to solve and get agreement on versus some of the other issues like employment, insurance. And the reason is one person's problem is another person's competitive advantage.
Right, right. Elliott, how are your clients interpreting the California law?
Exactly how I tell them to. No, I've seen a range. I think that most commonly the issue has been deciding whether or not a company is engaged in a sale of information under the CCPA. Many companies are taking a wait-and-see approach. They're implementing the right to know sort of access, the right to delete that consumers have, but as to the, excuse me?
Are they doing that nationally or only for California residents?
That varies as well. It really depends on how the company interacts with consumers, what information they have at that point that a consumer initiates an access request. If it's going to be really challenging for that company to make a determination, if that consumer making the request is in California, then they'll just treat that request as if they are for anybody who makes it. In other instances, if you're not in California, I'm sorry you don't have these rights. Just funny anecdote, we had a company who received a request from a consumer in Arkansas. Now, I'm not knocking Arkansas, but he first contacted a company and said, I want to exercise my GDPR rights. And they said, well, I'm sorry, you live in Arkansas, you don't have GDPR rights. He said, well, okay, then in that case, I want to exercise my CCPA rights. So I had to turn him away there too. But it really does vary. I think it makes sense, really on a company-by-company basis in terms of how they're scaling this solution and really what their underlying infrastructure is to deal with those requests and make those determinations. One of the things that I advise companies is to try to avoid a situation where you're collecting more information from a consumer in order to try to make a determination about their jurisdiction or in order to try to verify their identity when they are making those requests. More is less in that respect, keeping it relatively simple and straightforward and avoiding sort of this situation where you're suddenly, I guess, just scaling up the amount of information that you're collecting from this consumer just because they're enacting some of their rights under a privacy law.
Alison, what are you seeing in terms of agencies?
I mean, it's a struggle because a lot of the agencies, because of the intermediary aspect of it, makes it a little bit tougher for compliance. I mean, some of the questions that I've seen recently, for agencies, a lot of the big questions hinge around service provider, right? To what aspect you're a service provider.
And that's important because if a company's a service provider, then it doesn't have to honor the opt-outs, more or less?
That's a tough question.
Yeah.
Okay.
But that's unclear too, actually,
basic,
technically.
the basic structure that the CCPA contemplates is you're a business, you collect information. When you sell that information, you're selling it to third parties. Third parties are generally the types of parties that don't collect information directly from a consumer. They either get it because you gave it to them, or they get it somewhere else without direct consumer interaction. So an opt-out under the CCPA contemplates giving consumers the ability to notify a website that's collected their information. Not only do I want you not to use my information for purposes of advertising, or rather to sell it generally, including for purposes of advertising, but tell all of your advertising buddies, leave me out of this. Now, you might still receive non-targeted ads, you'll receive contextual advertising, and you won't receive no advertising if a consumer opts out. But the service provider definition is one where, say, companies have found maybe a means of establishing more of a contractual relationship with advertisers, and they're limiting their advertisers' use of information beyond their sharing of it. So advertiser can't get information from a publisher and use that in other advertisements, right, that aren't directly targeted to that publisher. So it's a way of limiting the use of that information that the CCPA recognizes, and again, doesn't prevent targeted advertising. It just creates a very particular structure that then has implications in terms of the consumer rights under the CCPA. So if you're sharing information with a service provider, you're still required to disclose that when a consumer requests what information you're collecting about them and who it is you're sharing that with.
But basically, an ad tech company could arguably be a service provider, and then the ad tech company could serve the targeted ads based on the data that the consumer has said not to sell.
Right. I think because of how broad sale is interpreted, and because I know the people at the California Attorney General's office, and they're, I think, unlikely to take a narrow view of the definition of sale, I think that there is risk associated with trying to narrow that definition of sale and exclude yourself from it. But the law is unclear, it's untested, the regulations aren't finalized yet, and we haven't seen the first round of enforcement action, which will start in July. I do expect that there's going to be a test case that is going to make abundantly clear what it is that the California Attorney General views as a sale of information.
And Alison, what else are you seeing?
Oh, no, I was just thinking one of the issues that I've seen a lot, Elliott could probably expound on this as well, is the issue around pseudonymized information, right? So a lot of companies who deal in pseudonymized information are like, I specifically deal in pseudonymized information because I don't want this identification aspect. I don't want this PI aspect. And one of the weirdly, and this is, as Wendy mentioned when she opened this panel, this is one of the things that happens when you pass an unbelievably untested, first of its kind, complex law in 5 days with no debate and no dissenting votes, which is how CCPA passed. One of the things that's happening is with the issue of pseudonymized information with consumer access requests, right? Companies are saying, but I don't have anything to re-identify it, right? But if there's an access or a point of it that has, the definition, this is another thing I don't think we talked about, but the definition of personal information under CCPA is one of the broadest definitions of personal information I think ever passed. It is extraordinarily broad. And for that reason, it kind of wraps in these issues around companies who say, well, I just have pseudonymized information. You might not under CCPA because that's not how they identify personal information. So you get a consumer access request that says, show me everything. You as a company are like, do I have to build a back-end system to re-identify pseudonymized information in a way that I didn't know who you were before I had to re-architect to define you? Is that utterly a little bit counterintuitive to the privacy incentive? So companies I've talked to are saying, well, what am I supposed to do with this pseudonymized information? Am I going to have to re-identify it? And there are some aspects that came out with the regulations from the AG's office that address a little bit about a reasonableness standard here. But anyone who's ever been involved with a reasonableness standard, you kind of know reasonable to who. So I think there's some untested questions about pseudonymized information.
Yeah, I think right now the law and the proposed regs contemplate that companies don't have to reconstitute de-identified or pseudonymized data in order to respond to a consumer request. Going back to an earlier point regarding harm to reputation and not complying, I think also seen now in this first wave of companies implementing the CCPA and responding to requests, a range of how it is that companies are responding and what kind of data they're disclosing. So, you might go to 5 different companies who are doing similar things in terms of data collection and use, but get 5 very different reports back on what information they have about you and who they've shared it with. There's computer scientists from UCLA who sent requests into some data brokers, and Experian, he called out in particular because he got back, sorry if there's anyone from Experian here today, but he got back a report which had the information he gave to verify his identity, and then everything else was redacted because it was deemed just too sensitive to disclose in the context of this
Apparently,
request.
some companies are asking you to take a picture and upload it and send it to them.
Right. So again, it goes back to what are you asking of consumers as you're verifying their identities? Are you gathering more information? What are you doing with that information? It creates all these ancillary problems. What is it that your company is responding with, and is it going to be interpreted by a consumer or a regulator for that matter as a good faith effort to try to be transparent and comply with the law and the kinds of rights that it's meant to enable consumers to have?
Right. No, I think we're just about out of time, but let me ask, are there any questions from the
Yeah, we have time
audience,
for
or-
questions.
Okay, great.
Mike's coming.
Hi, Lynetta Tai from Playwell Privacy Compliance. With respect to CCPA, a lot of companies I'm working with on the publisher side have been remarkably willing to drop their ad tech in the kind of, I would like to say months, but really in the 6 weeks at the end of the year, with the idea that, well, you know what, it's just too hot, the liability is too much, the risk is too high, let's drop them out, let's forgo the revenue, and let's deal with it in January. And a lot of what we're doing is now kind of methodically going through all of their third parties and seeing who can agree to a, quote-unquote safe harbor provision in their agreements, who can't, where the data is coming from. And what I'm seeing are, certainly companies like Google that came out very quickly with a solution, configuration solution, are winning. And for those clients who are on the ad tech side, who are taking a bit of a watch and wait approach to CCPA, how do you see the market shaking out? I'm seeing, some companies kind of taking the lead, and there's this window of time that I perceive where, when the solutions are there, the publishers are going to grab them, and others are going to lose. And I'm curious if you're seeing that, and if you're seeing that play out, and what that's looking like in the market.
I personally haven't experienced anybody just wholesale dropping their ad tech. I think that they've either, taken the approach that it's a sale and we'll deal with that accordingly and go through the hurdles of implementing the do not sell button and working a lot with vendors to make sure that solution is there and in place and reliable. More so, though, it's hedging on we don't engage in a sale as defined under the CCPA. If we do, we'll change what we're doing. But in the meantime, there's not a right on those sites to opt out. They're still going through the access to the rights requests and for access and to delete. But really just leaving the opt-out alone and waiting to see what others, competitors are doing and how they're implementing that.
Yeah, I think the combination for larger publishers of CCPA and Google's recent Chrome announcement have really pushed to the forefront the value of first-party data assets, right? I mean, there are a lot of publishers out there who, are not of the scale that they're ever going to have enough traffic volume to purely be self-sustaining on first-party data assets. But I think for publishers who can, there are aspects of CCPA and Google's recent announcement that are really pushing the conversations around first-party data assets to the front.
Well, with that, we have to wrap.
Okay.
Wendy, Catherine,
Thank you all.
Alison, and Elliott, thank
Thanks,
you
Wendy.
guys very much.